Welcome, members of the Seton Hall Law community and friends. I'm Professor Jenny Brooke-Condon, and I will be your moderator in this discussion of the President's executive orders on immigration. In the weeks since President Trump signed 3 executive orders addressed to immigration, many of us in this room have formed opinions about those orders, and I'm fairly confident, fairly strong opinions. Some of us have seen the pain and disruption on communities that we care about, friends, family, and our clients. And all of us who are concerned about national security, as we must be, have been forced into a national conversation once again about how we achieve it consistent with the Constitution and the rule of law. But no matter what opinions you bring into this discussion, as attorneys, we all have a common purpose. And that is our obligation to actually understand the policies, what they say, the facts, how they're being implemented, and the law that will govern the judicial decisions that will determine into the future whether or not they are lawful. To help us toward this effort, we couldn't have asked for a better panel of experts. Although many of you know them, I will introduce them. First, Professor Lori Nessel is the director of the Center for Social Justice. She's the director of the Immigration and Human Rights Clinic, and her expertise is in the area of immigration and refugee law. Next, Professor Jonathan Hafetz is an expert in the area of human rights, constitutional law, national security, and international justice. Finally, Professor Edward Harnett is the Richard J. Hughes Professor of Law, and he specializes in constitutional law and federal courts. Please join me in thanking all of them for helping us with this discussion. Before we get started, a few brief notes about the program. As you may know, the program will be divided into 2 portions. First, our panel discussion, in which I will invite a discussion from each member of the panel and then hopefully have a dialogue between each panel member. I will reserve some time for all of you to ask any questions. Then we will close the public portion of our program and invite any students who are and others who are interested in talking about efforts that are being undertaken to respond to the executive orders and how students may get involved in those efforts to stay. And my colleague, Professor Farinanello, will be joining Professor Nessel in that part of the program. Finally, because of the great interest in this program, I want to note that the panel discussion of the program will be recorded. So keep that in mind as you share your comments. To begin the discussion, I would like to ask Professor Nessel to provide us with a foundation for our future consideration of these issues, and to explain to us the 3 executive orders that were implemented last week and how they are being implemented on the ground.
Great, thank you. Okay, thank you so much, and it's great to see all of you here. It's great to pretty much fill up the auditorium. So I'm going to go over, like Professor Condon said, giving you just an overview of what the 3 executive orders are to begin with. I'm going to try my hardest not to wear my advocacy hat, but you will probably see it slipping back on from time to time. But I'm going to try to just tell you what these orders are. Okay, the first one is the protecting the nation from foreign terrorist entry into the United States. This is the one I'm sure everyone has heard about. This is what's been referred to as the refugee ban, the Muslim ban. Basically, there are 3 different parts to this. And so in this executive order, I'm going to take you through it because basically there are different bans that last for various amounts of time, depending upon whether you're a refugee, a Syrian refugee, or a national from one of 7 different countries, Muslim-majority countries that have been designated. So starting with refugees. All refugees at this point, pursuant to the executive order, are barred from entering the United States at all for 120 days. So now these are our overseas refugees, right? So people that have been waiting for months or years, have been through, and again, just a little advocacy hat here. This is the most extensive vetting that we have for any type of immigrants or our refugees. But until further vetting is put in place, they are now not allowed into the country, at least for 120 days. In addition, Once refugees are allowed back into the United States, the president has lowered dramatically, cut in more than in half the number of refugees that will be allowed once they're allowed back in to enter the United States. And so that will be cut from 110,000 to 50,000, that has happened before, but it hasn't happened in about a decade. So much lower number of refugees. And in addition, with regards, again, just talking about refugees now, the Department of Homeland Security has been directed to determine whether states and localities should have a bigger role in deciding whether refugees can be resettled into their jurisdictions. Okay, moving on to now another ban, this one particularly for Syrian refugees. This is indefinite, Syrian refugees. So obviously people that, from a refugee perspective, are perhaps the most in need of protection. Syrian refugees are banned indefinitely until such time as the president decides that it's in our national interest as a nation to allow Syrian refugees into the country. Moving beyond refugees, for people, now these are not refugees, these are nationals. So as written and as initially understood any immigration status, people that hail from 7 Muslim majority nations are also barred from entering the United States for at least 90 days. And those countries are, at the present moment, Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen. Other countries, pursuant to the executive order, states that other countries may be added to this list, and this may go beyond the 90 days. Okay, so those are, and again, I'm just highlighting because we don't have a lot of time. So those are just highlights of the first order. Second order, enhancing public safety in the interior of the United States. This, and again, just to highlight, this order provides for a massive expansion of interior enforcement. So enforcement priorities are going to be expanded to potentially include, so this is not criminal aliens, but now all unauthorized persons in the United States. There is no longer, under the order, there are not to be priorities. Everyone is equally prioritized for removal from the country if they're unauthorized. And this includes people that committed an act that could be charged as a crime. There's no requirement of a conviction. There's no requirement of an arrest. If you've, for this, committed an act that could be considered a crime. So that includes anyone that crossed our border unlawfully. There are other provisions, again, the interest of time, just go really quickly, compelling states and localities to go back to enforcing and increased enforcement of federal immigration laws, deputizing a broad band of state and local actors to become immigration agents without having provisions in place at this point to prevent racial profiling. Old things that had been tried and had been stopped because of constitutional concerns, like the secure communities, is now, it had been terminated since 2012. That's back in the law. There will be, you've probably heard about this, that the Department of Homeland Security is supposed to consider now removing any federal funding for sanctuary cities, for cities or for states that do not cooperate in terms of sharing information with immigration authorities. Last one, Border Security and Immigration Enforcement Improvements Executive Order. This one you may have heard most about in terms of this is the Build the Wall order. However, what I want to make sure you all know is it goes well beyond building a wall. There are provisions to dramatically curtail due process, particularly for people at the southern borders, massive increase in detention. Now people are to be detained. This hasn't been implemented. Well, we don't know. But as far as we know, it may not have been implemented yet, but it's now stated policy to detain individuals on the suspicion that they violated the immigration law. So again, not that they violated, not that there's been any decision made, but if there's a suspicion, people are to be detained. And the final thing I'm going to highlight from this is a very, very dramatic expansion in something called expedited removal. Expedited removal is something that already exists in the law, and the idea is it was aimed initially at our borders. And the idea is that if someone shows up at the border, they have no documentation or they have fraudulent documentation, they should be immediately sent out. Within as quickly as 24 hours, no hearing, almost no due process. But with an exception for people that fear for their lives and want to seek protection. In any case, that was then expanded within the law so that not just our borders, but within 100 miles, if someone was apprehended within 100 miles of a physical border within 2 weeks of having entered the country, they could be put in this expedited removal. The order now directs that it should be expanded throughout the country to the full extent, the full force of the law, which means it can be expanded into New Jersey. And it's now people that are put into expedited removal, which could be anyone who's here without permission, will, again, not get a hearing, be subject to removal within 24 hours unless they can show that they've been in this country for 2 years. So somehow within that 24 hours that they're detained, they need to convince the immigration authorities that they should not be in expedited removal and should be allowed to have bond and have greater due process. Okay, so that's a very, and unfortunately there's a lot more than that, but that's basically some of the provisions just so you see how they fit together and how broad it is. In terms very quickly of what's been happening so far, that part's quick because it's been real just chaos and confusion. Right, the order, particularly the first order, with the ban for refugees and nationals of the 7 countries and Syrian refugees, took effect immediately. And I think this, I don't think this has been contested, that it was put into place without consultation with the Department of Homeland Security or Office of Legal Counsel. So there was incredible confusion as to what it meant and how it should be interpreted. So when it initially it was being interpreted to apply to lawful permanent residents. So this was impacting people that had very long ties to this country, maybe went on vacation, went to their home country. Any national of one of those 7 countries was not being allowed back into the country. Also refugees that had waited years and gone through extreme vetting and were told, you're going to be resettled in America. We have a family waiting for you. They were given full permission of the law to enter. Well, when they arrived at airports, they were told, sign this, give up your rights, get back on the plane because you have no right to enter the country. The law has changed, and it changed while you were flying. You had permission when you left. You don't have permission when you landed. And so there has been some back and forth. There is now, the interpretation now, and the White House agrees with this, is that lawful permanent residents are not included within the ban. However, it is being interpreted to apply to people within the country as well in terms of processing for affirmative petitions, visas, things like that. So again, it's a really unclear because some areas are proceeding in a different way than others. The agencies are disagreeing, but for example, right now, the Vermont Service Center that processes asylum claims, work authorization, family-based petitions, employment-based petitions, they say we're not processing them. We can't process them if you're from one of those 7 countries. There are reports of again, real, very chaos and very different things happening in terms of how far this is going, and generally, I think I'll turn to you, but a climate of fear because no one knows what's coming next. There are incredible rumors. No one knows if they're rumors or if they're going to be the next executive order, what other countries might be put on lists. Initially, citizenship applications were held up as well. Now citizenship is moving forward. People are still taking an oath of naturalization, but anyone else is, I think, in a state of fear.
Thank you, Professor Nessel. As you can tell, there's a multitude of policies contained within the 3 separate executive orders, and we could have an extended, week-long discussion about the legal and policy implications of each of those policies. But I'd like to focus on the first one, the executive order entitled Protecting the Nation from Foreign Terrorist Entry into the United States, the one most of us are probably the most familiar with. And I would like to start our conversation by asking Professor Hartnett, and we're going to change places in just one moment, to start our discussion about the legality of this executive order. As many of you know, last week, Judge Donnelly in the Eastern District of New York, followed by several other judges, federal judges in other jurisdictions, enacted a nationwide stay, in that case, of the order, finding that there was a likelihood of success on the merits, meaning that the plaintiffs who challenged that law had shown had made a requisite showing that the executive order was unlawful. I'd like to ask Professor Hartnett to explain what the legal claims are by those advocates and what he sees as the open questions about how, regarding whether the courts will continue in that finding when they reach the merits.
I'm enough of a text guy that I'm going to show you some text. I had checked it in the other room to be sure it was large enough for you to see. I'm less confident that it's going to be work here, but I'll do what I can. Obviously, there are way more legal issues than we can possibly address here, and there is lots of confusion, lots of litigation. So everything that I say here is sort of a high-level overview and inherently tentative. And in addition, I guess the other thing I'd want to say before launching into some of the legal discussion is to just make clear that I think there's an important distinction between what's legal and what's constitutional and what's moral, wise, and just, that we shouldn't simply equate those two things. As one example of, I think, sort of the confusion, at least as I understand what then Acting Attorney General Yates said, the Office of Legal Counsel did vet these orders, maybe not as fully as ordinarily would happen, but there are conflicting reports about that as well. So we don't even know confidently what level of sort of legal review there was. Okay, I promised you some text. So, oh gosh, this is probably not going to work in this room. Does this work at all in this room for people? Yeah? Okay. Okay, this is the bar on entry part of the executive order. That is the president declaring pursuant to Section 1182F, proclaiming that immigrant and non-immigrant entry into the U.S. from aliens referred to in 8 U.S.C. 1187A12 is detrimental to the interests of the United States and thereby is suspended with certain exceptions. Some of you may be saying, wait a second, I thought it was 7 countries, listed countries. Those aren't in the order. Instead, there's a cross-reference to this 1187A12. What's 1187A12? 1187A12 is a 2015 statute dealing with the waiver with a waiver visa program that said basically we're not going to let this certain visa waiver program apply. This is Congress speaking. Apply in Iraq, Syria, or any other country or area of concern that the Secretary of Homeland Security designates. And what will the Secretary look at to designate those areas? Look at things like are there foreign terrorist organizations with a significant presence in the area, and is the country a safe haven for terrorists? So that Iraq and Syria are on the list because Congress put them on this list. The other countries are on this list because the Obama administration treated them as areas of special concern, albeit areas of special concern for purposes of a visa waiver program. What President Trump has done is take that list of countries that the Obama administration had keyed into for a visa program and use that list for the exercise of his power to suspend entry. Where's the authority for the claimed authority for him to suspend entry? That's 8 U.S.C. 1182F, which broadly says whenever the president finds that the entry of aliens of any class of aliens would be detrimental to the interests of the United States, he may by proclamation, and for such period as he deems necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on those aliens any restrictions he may deem to be appropriate. So that's the claimed statutory authority here. What's sort of the pushback, the legal pushback that can be raised? I mean, there are lots of possible ones, a couple of ones I want to highlight. One is a possible statutory claim based on the 1965 Immigration Act, and there we've got to look at interplay between multiple statutes. Then secondly, at least a couple of constitutional claims I hope to mention very, very briefly, and yell at me when I'm going on too long, please. What's the statutory claim? Well, there's a statute that Congress enacted in 1965 that forbids discrimination with regard to the issuance of immigrant visas on the basis of race, sex, nationality, place of birth, or place of residence. So there's a statutory argument that this 65 statute qualifies the president's power under this 1952 statute so that he can't engage in nationality discrimination when exercising that power. That's a possible statutory claim. There are potential weaknesses with that statutory claim. This statute talks about preferences with regard to immigrant visas as opposed to entry. There's got to be questions about whether this specific grant of presidential power is trumped by this general prohibition on discrimination. Maybe it is because the general ban is later. But it also has to deal with the practice. That practice under the 1952 statute has involved more than 40 times where various presidents have invoked this power, albeit on a much more limited basis. And almost all the time that it's been invoked, the target of the restriction seems to have been, at least in effect, limited to the nationals of particular nations, even if not by its terms. For example, things like people involved in particular activities in particular nations. Well, maybe not all people involved there would be nationals of that nation, but almost all would be. But there's a statutory argument that bans this kind of nationality-based discrimination under the Immigration and Naturalization Act. How about constitutional doctrine? I think the big problem for challenges here, there are lots of potential problems, but the biggest problem is the plenary power doctrine. That is the very old doctrine from the Supreme Court that says that the political branches have plenary power with regard to controlling entry into the United States. This goes back so canonically to the Chinese exclusion case in 1889. I mean, I have some of the language here that some people may find offensive, but I think it's worth making sure that people see it. The Supreme Court told us that to preserve its independence and give security against foreign aggression and encroachment is the highest duty of every nation, and to attain these ends, nearly all other considerations are to be subordinated. It matters not in what form such aggression and encroachment come, whether from the foreign nation acting in its national character or from vast hordes of its people crowding in among us. Concluding that the government has the authority to decide when people will be admitted and when not. And once the legislative department so decides, the judicial department has nothing to say about that. That is the case that the determination is conclusive upon the judiciary. Now, obviously, an 1889 decision is rather old, and there's been lots of changes in constitutional law since then. But for better or worse, while this plenary powers doctrine has been widely criticized and significantly sort of nibbled at, I think it's fair to say it has not yet been overruled. Where do I think the conceivable sort of places to make a dent in the plenary power doctrine might come from this in this area? It seems to me there are two possible arguments here. One is based on a claim that because in most circumstances, nationality discrimination would be unconstitutional under the Equal Protection Clause or the Equal Protection component of the Due Process Clause. The same thing should be applied to control over the borders. Maybe so, but I think that would be a really dramatic change in our constitutional law. I mean, think about it in the extreme of war and peace. Would any court really want to say as a constitutional matter that the nation must treat the nationals of those nations with which it is at war, the same with which it is allied against those at war. Far more likely, it seems to me, would be an argument to erode the plenary power doctrine based on a claim of religious discrimination. I think that if something's going to give here, it seems to me that's the most likely thing to happen. And here you have really interesting sort of questions of how how a claim of religious discrimination would be proven and sort of received by courts in this area. That is, if you look at the face of the order, it's not about religious discrimination. Where do you get the religious discrimination? You turn to all of the campaign statements and perhaps the Rudy Giuliani statements. How much will courts be willing to rely on those to conclude that a presidential action was unconstitutional because improperly motivated, unconstitutionally motivated? It seems to me is in the long run going to be one of the key questions here. I'd love to talk about the funding cutoff, but I should probably be done and move on. And if we have time to talk about the funding cutoff, I'll deal with that then. Thanks.
Thank you, Professor Hartnett. I'd like to open it up to Professor Hafetz to respond generally to some of the comments of Professor Hartnett about the legal questions. But in particular, Professor Hafetz, given your expertise in national security law, I wanted to ask you specifically how much the courts should defer to the executive in determining whether or not the executive order and the policy it seeks to achieve actually achieves protecting the United States from national security, and whether or not the admission is actually detrimental to the United States. What role does deference to the executive in matters of national security matter here?
Yeah, well, thank you. And thank you all for coming. It's great to see so many people here. And I'll just try to respond to you and fill in on the excellent presentations by Professors Nessel and Hartnett. So I think, the deference is an important question, certainly under the plenary power doctrine. But I think that you see a very clear example of executive overreach here, both in terms of what the orders seek to do and in terms of the process on which they were implemented, which is at best haphazard. I think it's, and then on your point, I think also the other fact which will play to the interpretation of the detrimental to the interests of the United States, and it also plays into what Professor Hartnett was alluding to in terms of the question of purpose behind the orders are kind of the facts and the statements. I mean, I think there's no serious data that I've seen, none, that suggests that the refugees pose a threat. I mean, there's just the evidence is on the other side that what's happened is harmful to the United States. You don't take my word for it. You can look at the statements of people within the State Department, foreign relations officers, people within the military, people within the intelligence. I mean, this is harmful. So I don't think there's really no evidence on that point. So I think, to me, I'll go into the doctrine because I do want to pick up a couple points, but I think what you may see here is quite similar to, and you've already seen it with the judicial pushback at the district court level, is the court's response to this overreach and sort of the executive acting, in ways that don't seem principled, arbitrary, disregard for facts, and the court's pushback. And I would draw your attention to and another area where there's usually tremendous amount of deference, and that's the war powers. And yet, you could see playing out something along the lines of what happened during the Bush administration, where the Bush administration, cut out experts within the government, pushed a sort of very aggressive view of executive power, their disregard for international law, and suffered 3 consecutive defeats in the Supreme Court on issues of executive war powers, and moreover, those actions followed the most dramatic and worst terrorist attack in the United States history, as you all know. And yet even still, the courts respond. So I think that the way that both the sort of the substance of the Trump administration's positions and the way that it is implementing them is going to cut into and undermine their claims for deference. Courts are simply, going to be more cautious about giving deference to an administration or frankly, to a president who, repeats publicly that he won the popular vote and that millions of illegal immigrants voted, which is just false, right? So I think those are going to, and I'm going to go into the doctrine in a minute, but I do think that as a kind of realist approach, I think courts do have that on their mind because I think they're concerned about some of the broader sort of separation of powers issues. So on the doctrine, questions of doctrine, Eddie focused on the plenary power doctrine, which I think is right. I think that's going to be one of the major challenges that the petitioners will have to overcome. But I would say that the doctrine is it's something of a relic. As Eddie noted, it dates back to the late 19th century, and the case that he referenced, the case that was decided at the time of Plessy versus Ferguson, and the sort of suggestion that the government could discriminate based on religion or certain other criteria, certainly based on religion, is inconsistent with the domestic anti-discrimination jurisprudence that you see from Brown versus Board of Education forward. So I think that the court is I think that the plenary power doctrine is vulnerable. There's a case now that was argued in the Supreme Court just a few months ago called Morales-Santana versus Lynch, which involves a statutory provision for conferring citizenship on children born abroad that treats men worse than women, requiring that they have lived longer in the United States to pass citizenship on to their children. And from the transcript, this is all before this all happened, there was skepticism about that, and so I think that there's I don't know what will happen, but I do think that the plenary power doctrine is vulnerable. The other constitutional challenge, Eddie talked about the equal protection challenge, and I think the religious or the establishment clause, talked about religious discrimination, one of those two, but the others are the due process issues. And so there, the question that's going to come up, the sort of second doctrinal hurdle that the petitioners are going to have to overcome, besides plenary power, is the territorial limits on the application of the Constitution. So, traditionally, or for a long time, the understanding was that the Constitution did not extend to non-citizens unless they were physically present within the United States. And so it didn't extend to non-citizens outside the United States. It only extended to citizens outside the United States. Immigration law, there's a Supreme Court cases, a famous, or for many an infamous case called Mazzei, in which the court suggests that even if non-citizens are actually at the border, right, so even if they're at the port of entry, they are not treated as though they're in the United States. They're still treated as though they're outside of the country, and thus don't have due process rights. I think that argument is also vulnerable and has been eroded significantly by a decision that many of you will have read called Boumediene versus Bush, a 2008 decision of the Supreme Court, which said that the habeas corpus suspension clause, potentially other constitutional provisions, apply to non-citizens at Guantanamo, even though Guantanamo is not part of the United States in terms of political sovereignty. And so the argument will be that if the executive if Constitution potentially applies to non-citizens at Guantanamo who are being held under the war powers, a fortiori it should apply or potentially apply to non-citizens who are seeking entry to the United States. I think certainly that the legal permanent residents who were stopped at the border, that's I think a very easy case. But I think that the court I could see courts extending those rights to others, and even to others who are awaiting to come to the United States that are still in foreign countries, but have received their visas or permission to come to the United States, as they have some kind of interest and stake. So I think that that's going to be the procedural issues are going to be important, and they're going to play out in a number of different ways. I think one of the most important ways is that federal statutes, which in some cases implement international obligations under refugee convention, under human rights treaties, require that individuals have the opportunity to apply for asylum, that they cannot be sent back or returned to countries where there's a risk of torture or other persecution. And so they have a right to relief, and they have a right to review, including judicial review. And so to the extent that the executive order denies those rights, I think it's going to give rise to real due process issues, which may affect the interpretation of statutes under constitutional avoidance issues, or may just lead to invalidation of parts of the executive order. So the last thing I want to say is I want to just point out there are actually a couple of Supreme Court cases. I mentioned one before, but a couple of others that are actually pending already that could directly bear on the issues raised by the executive order, as well as various other orders that the Trump administration has issued or will be issuing. So one of them, Professor Nessel mentioned, the expedited removal program. There's a case now that's before the Supreme Court on a petition for certiorari called Castro versus DHS. This case involves the migrants from Central America, mainly women and children who had been fleeing persecution and who were detained. A number of them who were already inside the United States and who were detained and in removal proceedings. And the Third Circuit decided that ruled that those individuals were not protected by the habeas corpus suspension clause. This is a very controversial ruling. I think is very weak because the long and settled understanding, and I filed an amicus brief with various other constitutional law scholars in the Supreme Court saying this, that these individuals, that the suspension clause is always applied within the United States. So whether it applies beyond and where else it applies, as discussed in Boumediene, it's always applied in the country. And I think that this case is going to be obviously very important now that we have this potential expansion of the expedited removal program, not within the United States into major cities that are within the 100 miles of the border. And so the notion that people can be arrested, detained, and removed without judicial review, I think the court is going to be much more likely now to take this very important case. There's a couple of other cases. One's called Jennings, which involves due process rights of individuals in immigration detention and whether they can be detained for more than 6 months without any kind of hearing. So that's another important case. And then there's another case which is dealing more with prospective, damages relief, not prospective relief, but relief after the fact. It's called Abbasi. This was a case that arose out of the immigration sweeps after 9/11, which hundreds of Arab and Muslim men were rounded up based on virtually without really any kind of individualized suspicion, and placed in extremely harsh conditions of confinement. And held for long periods of time without any kind of review. Now, there have been a couple of Inspector General reports that have criticized this policy, but there's also a damages suit that was just argued in the Supreme Court in January against former Attorney General Ashcroft and former FBI Director Mueller, seeking damages for constitutional violations of equal protection and due process. Most people thought that this case was going to be a very difficult case, really having to do not so much with the application of the Constitution, but the restrictions on damages remedies and the erosion of a case called Bivens, if you're familiar with this area of law. But I think that case is now, the stakes are raised much more now, and the court is going to be thinking, hopefully, a lot more carefully about accountability, given some of the potential risks of having some kind of check. So, and then one other case, which I think is both legally and politically important, called Hernandez. This involves a cross-border shooting of Mexican youth by U.S. Border Patrol agents, and there's it's a damages suit. And like the Abbasi case, the only question at this point is whether or not the plaintiffs actually can get into court and bring their claims. But this case raises both a question of accountability and also the application of constitutional protections to individuals right outside the border, which is obviously implicated by the immigration executive orders that Professor Nestor talked about. And so I think that, plus there's also a political dimension to this case now, which I think the stakes are much higher. You all read the papers and have been following what's been happening between President Trump and the Mexican president. So that's to say there are these challenges in district court that are going on, that are playing out at a very fast pace. But there are also existing cases that predated the Trump administration that are in the Supreme Court, and that I think that the justices, some justices, are going to look at through a different lens, given the development of the last 12 days.
Thank you. We're getting